next speaker is Yuhui Liao, partner of Luther Law Offices, China. The focus of Yuhui Liao's advice lies in foreign investment law in China, as well in corporate law and commercial and distribution law. Please.
Well, good afternoon, everyone. So many thanks for the video and many thanks for the opportunity to give a speech here. I'm talking something about the arbitration or the recognition and enforcement of foreign arbitral award in China. Well, first of all, I want to make a very brief introduction about myself and my firm. So we are a firm here in Shanghai with the Luther brand. Luther is a German brand based in Germany, but with several overseas offices in Europe and in Asia Pacific region like Shanghai and Singapore. So we are dealing a lot with advisories on foreign investment in China, and the other way is that means Chinese enterprises in their outbound investment. So that's our office in Shanghai in the business center. Okay, good. I remember one of the speakers of yesterday told us all that China is a difficult market. Yes, it's true. And it's true for us all, also for me, for us, my firm. So at least the Chinese legal service market, it's more than restricted for foreign law legal advisors. So what we are doing, we are a local firm based in Shanghai, but we are also associated with the international network of Luther. So that means we are a local law firm and we can do everything. That means including litigation. So for the greater region in China, when we talk about China there, we often talk about the 4 different parts in the greater China region. So the mainland China, it's a signatory state of the New York Convention since 1987. And there are Hong Kong Special Administrative Region and Macau and Taiwan. So inter-regional agreements, there are inter-regional agreements or treaties between these parts, so that we can make a certain advantage for foreign contract parties. Let's say if you are advising your client, a foreign company who's concluding a contract with a Chinese contract partner, and the Chinese partner says, well, we can accept arbitration clause, but I'm afraid Stockholm is too far away and Vienna is too far away, so how about Hong Kong? Then we can say Hong Kong Arbitration Center, there will be a certain advantages because mainland China and Hong Kong, they have both parties have an arrangement so that the Hong Kong, an arbitral award made in Hong Kong can be enforced by a Chinese court without difficulties, that means even without a procedure for recognition. And how is the procedure and requirements? So generally, you can expect that China is implementing all of the rules under the New York Convention. And for the timeline, there is a certain fixed time limit. So that means if you have received an arbitration award from a foreign arbitration institution, you can submit this application to a Chinese court. And the timeline for that, there is a limitation for period of limitation. That means that is 2 years, within 2 years after the expiry of the time limit for performing the obligation provided under the arbitral award. You have 2 years if your Chinese contract party who is the debtor who fails to perform his obligation. You have 2 years time to prepare and submit the application for recognition with the Chinese court. And which of the Chinese courts are competent for that? So it's basically the court that accepts your application for recognition of an arbitral award is an intermediary court. So that's actually somehow similar like an appeal court, if you compare it with many other countries. So that means you needn't submit the application to a court at the basic or primary level where generally you can say where intermediate court, you have there better lawyers, better qualified lawyers with more international experiences and better educational backgrounds. You can say that, roughly. So that's one of the parts of the mechanism how the Chinese system is trying to ensure the quality of the international arbitration practice. And after acceptance by the court of your application, the court will have 2 months' time to review the application. And there will be reviewed whether any of the conditions provided under the convention are satisfied to justify a refusal of the arbitral award and its form review. And if, generally you can expect that if there's no conditions satisfied under either of the reasons for refusal, you can expect the arbitral award can be recognized and enforced by the Chinese court. But theoretically, it's 2 months. And later we come to another slide and we can see how long it will take in practice. And if the Chinese court is a first instance court, I mean here the intermediate court, the first court who accepts the application, if it thinks fit to support or approve the application, then it should make decision within 2 months. And after these 2 months, there's a time limit of 6 months for the court to enforce the arbitral award. So generally you can see there are 8 months. Ideally, we can finish that within 8 months. But you see, there's certain, I'm not sure if it's very special just in China or there are also similar practice in other countries. If the first instance court thinks there is a reason to reject the application, then the first instance court needs to report it to the court of a higher level. That is usually the higher court on the province level. So there are 31 or 32 provinces in China, and the first instance court should report to a higher level court. And if the court on the province level, the second instance, thinks it's a fit where you can approve it, then the first instance court will approve it. And if the second instance court thinks there is a reason to reject, then the second instance court will report this case to the highest court of China in Beijing. So that's the Supreme People's Court in Beijing. And until the highest Supreme People's Court makes a final decision. So with simple words, if there is a reason, if the first instance court thinks there is a reason to reject the application, there will be 3 instances de facto. So there was a reason for that because until 15 or 20 years ago, there were practices of local court, where local court, there were certain cases where the judges tried to extend the interpretation of a certain public policy and using that to try to protect the local companies in their interests. So that's why the Supreme People's Court had ordered this procedure so that they can guarantee that the application can be treated fairly with high qualified lawyers and with sufficient review procedures to make sure that it's fair treated over all membership, over all other signature states of the convention. So actually it's even more advantageous for foreign parties who go this way, because for normal domestic arbitration procedure in China, you don't have this 3 instance system. One off judged by the court, that's all, for domestic arbitrations. So there are some details how you should submit application for recognition in China. So we have talked something about that, and you may choose if you choose the court, if there is a choice to which intermediate court you should submit your application in case, for example, your award debtor has some assets, and these assets are on different locations. There may be a reason for you to consider, to help your client to think, which court can we choose, where there are certain factors that you should consider. Because for the Chinese coastal regions where there are better lawyers, you can expect that the legal infrastructure there is better than the land far, far away. And you may choose, if there is a chance, you may choose those courts in some higher developed regions like Shanghai or Beijing. I said there are 2 years. And which documents are required? I think it's prescribed under the convention, but just keep in mind that you should advise your client that there is a very strict document form request that you should prepare. And later we will see the percentage, how many documents, how many applications are rejected just due to failure in meeting form requests. Timeline, we have talked about that. And there are certain key figures at a glance. And we can see that these figures are calculated by us, by my supporting team, by hand. So we reviewed all the cases of international arbitration award recognition and enforcement in China since 10 years. We can see not all, that means not all 100% of the arbitration award were recognized in China, but only 74.6%. I'm not sure how much is it in other countries, but 74.6%. That's enough for you all to remind your clients that everything should be prepared very carefully and starting already from the negotiation with a Chinese contract partner, even before you enter into a sales or other kind of commercial contracts. And how many days does a Chinese court need to recognize an foreign arbitral award? If it's a positive decision, that means if the first instance court wants to decide to approve the application, it takes 306 days in average in the last 10 years. And if it goes to the second or even the third instance court, and finally the Supreme People's Court in Beijing makes the final decision, it takes 520 days in average. So that's the results of our own calculation. And as we said, the three instance procedure, it happens very often that the first instance court believes this or intends to reject the application, and then the court is obligated to report it to a higher level court. And in the end, the opinion by the first instance court was either approved or rejected by the higher court, about 50-50. That means if the first instance court says, no, we reject application, don't be disappointed, there is chance still. And it's very large number actually, 32.3% of refusers. The reasons for refusal is just because the arbitration agreement is invalid. We can come to that in a later slide. And for myself, my team has worked on quite a few cases where the international contract dispute, let's say sales contract, for example, provides a certain arbitration clause. And the arbitration clause even provides an arbitration institution in China that does not exist at all. So obviously, I suppose when the parties were negotiating this contract, they did not have sufficient communications with the Chinese lawyers, at least. And how much does it cost to receive a recognition or recognition of the arbitral award in China? It's just $78. And for enforcement, there are certain examples here, and it's treated like the same like domestic arbitration award, how you enforcement. There are challenges like everywhere. Well, so far I have collected these ideas, which kind of challenge you may face while the procedure in China. And I think there is a long procedure that you should be quick because period of limitation is just 2 years, and there is a long duration for processing. But just now, since yesterday, I heard from many colleagues from other countries that it can be even longer, 5 or 6 years. So obviously, this is not only the problem for China, but also for many other jurisdictions. And the most difficult, enforcement. So enforcement is a traditionally very, it's a kind of headache for all creditors or lawyers, but also for courts, actually. We have collected a summary of the percentage, how many, which reasons is imposed for the Chinese court to refuse to recognize a foreign arbitral award. So this is an overview about that. We can see above, on the top is 32.3% of refusals are because that the arbitration agreement is invalid. It's where it's really a large amount. I had thought actually if we just think it very blindly, I think if you hire a lawyer, which is careful enough to check the law of the location where you seek for arbitration, and also the law of China, you should have been able to avoid that. Well, checklist. What should we do? What would you advise your client before and after the procedure in China? As we said and talked, there are certain factors for consideration before you help your client to enter into a commercial contract with a Chinese contracting partner. So there is a choice which arbitration institution we can choose, and which law should be the governing law in China. And there are many cases involving joint ventures. For joint venture companies in China with foreign and Chinese investors, there is a mandatory request by Chinese law that Chinese law should be the governing law. And the Chinese court, if you seek for a lawsuit via Chinese court, and then Chinese court will be the sole court competent for dispute. But you can seek for arbitrational institution. You can provide an arbitration clause in a joint venture contract. Even for joint venture contracts, the Chinese law is mandatory. So that brings a certain advantage that you as a foreign legal advisor, you can advise your foreign client where if we do not have enough trust in Chinese courts, and we can consider about arbitration. And in fact, there are good arbitrational institutions like CIATEC in China, and also, for example, Shanghai International Arbitration Center, that's SHIAC, and one of the arbitrators is here, Mrs. Xu from China. We got to know each other yesterday, but we have decided spontaneously to build a China delegation here on this wonderful event. Make sure the validity of the arbitration agreement. So there are a lot to study and to consult. If you are working with a Chinese colleague, you should consider that beforehand as early as possible. And after that, if you are going to file an application to arbitrational institution, and you should you should study very carefully the reasons, for example, in the past year, why a Chinese court could reject a successful arbitral award, even you won the case. That means you should you should observe very strictly all these document requests. You should have it, for example, translated with a certified translator, and how far this can be accepted. Perhaps different courts will have different implementations. And you should itemize your claims. That brings you the chance, makes it possible if the Chinese court thinks part of your claims can be justified and approved, while the court can reject another part of the remaining claims. That makes it possible. Potential violation of Chinese public policy, so that's not so terrible like it sounds, because China has really implemented guidelines that a violation of Chinese public policy can only be interpreted in a very strict meaning, so that you may rely on that, if there's a certain arbitral award made by a foreign arbitration institution which has breached a certain mandatory request by Chinese law, it's not yet a reason to be afraid that the Chinese court will reject it by referring to this public policy. Enforcement, as we said, it's a big reason to cause headache because there are certain difficulties in China where there's let's say the asset of the companies or individuals. There are no transparent or regulated ways to check it, how you can investigate. And while you apply to a Chinese court for enforcement, you may need to find out by yourself what kind of assets the debtor has and where is it, and which bank accounts do they have, and which vehicles, or which land, which houses do they have. The court can help a bit if you apply, but in many cases you should collect it by yourself. That's again a challenge, how you can find the leads. There are certain maybe good advices from your Chinese lawyers when there's a case for that. Enforcement procedures, there are different procedures. You apply it and that can be enforced. There can be objections from the debtor or objections from the third party, and there may be change or addition of the enforced subject, and there may be suspension, termination, where an enforcement is, as I heard from some friend as a judge who is working at the enforcement department or court, actually quite a lot of enforcement cases in China via Chinese court, they end in nothing. So that's actually a factor enough for you to remind your clients of the needs that one should really be very careful as early as possible. You should make good contract. You should take certain measures, for example. And for this, it's another factor for you to choose a Chinese arbitration institution like CIATAC or SHIAC or something else, because if you choose an arbitration institution in China and make the arbitral award in China, you may have an advantage that you cannot have if you receive arbitral award from a foreign arbitration institution. Why? Because the Chinese legal framework has provided for a possibility that if you receive an arbitral award from a Chinese arbitration institution, you may have the chance to apply to the court for preservation. That means to freeze the assets, bank account of your debtors even before you take substantial procedures again via the court, via the enforcement, via the arbitration or enforcement procedure. While for foreign arbitral award, you don't have chance to do the same. There are a lot of difficulties, but the Chinese government is lawmakers and Chinese governments and also courts, they are improving, and they have really very good and new ideas, so that a nationwide platform for blacklisted debtors have been founded, and you have the chance to check via internet if a certain person or certain company is already blacklisted as a certain person that is blacklisted in this so-called credit list for those persons who have failed to cooperate in enforcement. And the court has very good ideas. Let's say, for example, if your Chinese contract partner who is a debtor, either as an individual person or as a legal representative of the company, if he is blacklisted by the Chinese court, then he loses many chances. For example, he uses his ID card. Chinese ID card has a chip card in that. If he is blacklisted, he can't even get a high-speed train ticket. He can't check into a luxurious hotel. He can't take a flight. The Chinese court worked together with the telecommunication companies. If you call that guy, you may perhaps hear a color ringing tone saying that guy you're calling is blacklisted. I'm come to the end. There's a certain case study where we have experienced in the past years. It's a long story, with a joint venture dispute between a German company and a Chinese company, and it has taken quite a long time, since 2013. And if you have interest, we can communicate after the speech. It's a typical example how where you win the arbitral award and you receive a recognition by the Chinese court, but by enforcement in the procedure, what kind of difficulties the court can make in order that you do not get it enforced so easily. So that's all from my side. I thank you all for your attention, and that's me. Thank you very much.
Thank you for beautiful presentation.